The accused inflicted injuries on non-vital parts of the deceased, which were not found to be sufficient in the ordinary course of nature to cause death. But it was proved that he inflicted the injuries with the knowledge that with these injuries the victim was likely to die. Now, whenever we are confronted with a question of this kind, a question whether offense of culpable homicide or the offense of murder has been made out or not, let me complete the question. The complete question is, the case would be punishable under which section? 302 if it is murder, 303 of course is now has now been struck off, so it's not relevant. 304 part 1 and 304 part 2. 304 applies when it's the offense of culpable homicide has been committed. 302 applies when the offense of murder is committed. So obviously the question is asking us whether an offense of murder, an offense of culpable homicide has taken place or not. Whenever we are confronted with such question, we have to see two things. Firstly, there must be death of a human being caused by another human being. And secondly, the intention or knowledge. As per the facts given in this question, what is the intention of the accused and what is the knowledge of the accused? As far as intention is concerned, nothing is given. The accused inflicted injuries on non-vital parts of the deceased which were not found to be sufficient in the ordinary course of nature to cause death. This is an objective statement. Nothing is said about his intention. In the second part of the question, something is given about the knowledge of the accused. So since the question talks only of the knowledge of the accused, not of his intention, our answer will be dependent on this fact, and for finding out the answer we will straight away go to section 299 where culpable homicide is defined. Whoever causes death of a human being, all right, by doing an act, so there must be an act. And then we see whether there is an intention of causing death, whether there is an intention of causing bodily injury which is likely to cause death. And if there is no such intention, then lastly we will see whether there is knowledge at least that by this act he is likely to cause death. Since there is knowledge, it will amount to culpable homicide, definitely. There is knowledge that the act is likely to cause death, or the injuries are likely to cause death. So it is covered by the third part, knowledge. Now, next we have to see whether it amounts to murder. As far as the first two parts are concerned, intention, it will amount to murder if part 1, part 2 or part 3 of the definition of section 300 becomes applicable. As far as knowledge part is concerned, this act will amount to murder if part 4 of section 300 is applicable. Since nothing more is given to us, we are only given that the injuries were not sufficient to cause death in the ordinary course of nature. But we are not given anything further about the intention or the knowledge. Therefore, 300 will not apply, only section 299 will apply. It is a case of culpable homicide, and it is culpable homicide because the accused had the knowledge that the injuries he is causing are likely to cause death. So the punishment will be under section 304. Now section 304 has two parts. We have to answer as to which part will be applicable. Yes, anybody who can tell me which part of section 304 will be applicable? 304 part 1 or 304 part 2? As such, 304 is not divided in these distinct parts as such, but that's how we commonly use. And Smita says part 2. Yes, very correct. I am showing you the section 304. First part says, whoever commits culpable homicide not amounting to murder shall be punished with this punishment if the act by which death is caused is done with the intention of causing death or with the intention of causing bodily injury likely to cause death. 304 part 1 will be applicable where the death is caused with these two intentions or any of these two intentions. So there must be some intention. In our question, there is no mention of intention. They are mentioning only about the knowledge of the accused. As far as knowledge is concerned, the second part will apply. This is the second part. Whoever commits culpable homicide not amounting to murder shall be punished with this punishment if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death or without any intention to cause bodily injury which is likely to cause death. In our case, it is the knowledge, there is no intention as mentioned in the question. Therefore, the act of the accused amounts to culpable homicide and it is punishable under section 304 part 2, where the punishment is imprisonment up to 10 years or fine or both.